Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
What's their actual move going to be to make this at least look like a win? What's their next step of their defense going to be, given that the evidence surrounding their claims is so weak? Well, John Deaton has shared what might end up being their very last-ditch effort, and so I want to talk about that. And also, at the end of the video, I want to give you an update on this story I reported on a couple days ago. Here's the headline from the Washington Post. Feds arrest married couple sees $3.6 billion in hacked Bitcoin funds. And so I reported, this has been big news over the last few days. This story happens to have been from February 8th. But this couple, married couple living in New York, part of the biggest seizure of assets in history. That's what's being reported, at least by the Department of Justice anyway. $3.6 billion. And the reason I wanted to provide an update on this case is because something hilarious has come to light. And it's hilarious because it's so absurd. And so I'll explain what I mean, but I'm going to share that towards the end of the video. I do want to be clear at the outset, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast. I enjoy making YouTube videos about crypto topics, but just as a hobby and just for fun. Now, before delving into what John Deaton had to say, I want to make sure that you are aware of a legal concept, because it's at the heart of what John Deaton's getting to, and it's not complex or anything, but I thought it might make sense to start with this, that you can see where John Deaton's ultimately going to go with it before jumping in and then having to pause and go back to this. And so I just went to law.com, and here you have, you can search for legal terms and definitions on this website, and so here is the but-for rule, which John Deaton ultimately references, and it's described as follows. One of several tests to determine if a defendant is responsible for a particular happening. In this test, was there any other cause, or would it have occurred but for the defendant's actions? And so, for example, they write, but for defendants driving, being wild, just wildly speeding, the car would not have gone out of control, and therefore the defendant is responsible. This is shorthand for whether the action was the proximate cause of the damage. So if you want to just really sum it up in a nutshell, just understand what we're saying but for, it's shorthand for whether or not the action being cited was the proximate cause of whatever the damage is, the end result, proximate cause. Just remember that part and you'll be good. And now into this thread from attorney John Deaton from just a few days back. Here's what he wrote. XRP itself is a security per se? Although designated amicus counsel, I have not yet been privy to the non-publicly disclosed or sealed documents that have been exchanged between the parties or filed with the court. For some time now, I've been troubled as to why the SEC wouldn't stipulate that XRP itself, including secondary market XRP, are not securities. After reading these emails and anticipating what the 2012 legal memos likely state, I may finally understand why the SEC won't stipulate the token itself isn't a security, a stipulation which would rid the SEC of amicus counsel along with his 64,000 XRP holders. So pause and think about that. The SEC has an easy way to get rid of John Deaton, they just don't want to do it, because what would they have to do? Stipulate that XRP itself isn't a security. That's it. That's pretty much it. And then bam, John Deaton's gone. All of these 64,000 plus XRP holders gone. Because you do what you will with Ripple, SEC. I don't even feel like at the moment speaking as to the validity specifically on that, because what I'm most concerned about, in particular for the purposes of this video, is what's happening with XRP and what's happening to XRP holders as a result of all this. So you gotta ask, why won't the SEC declare something like that? Well, John continues. When I filed the motion to intervene, or in the alternative be granted amicus status, Ripple informed the court that if the SEC agreed XRP wasn't a security per se, XRP holders lacked standing to participate. If, however, the SEC intended to argue XRP itself is a security, Ripple argued XRP holders should be allowed to participate in the case. The SEC not only refused to stipulate XRP itself isn't a security, but actually argued all XRP are illegal securities. I've always always questioned why. The unsealed emails and legal memos are barely relevant. An illegal securities offering analysis focuses on the promises or inducements made by the promoter to investors, leading those investors to anticipate profits from the efforts of the promoter. Brad Garlinghouse and Chris Larson's emails or legal documents were not made public. It will be near impossible to prove any real correlation between XRP's price and public announcements by Ripple, i.e. partnerships. The SEC must also prove Garlinghouse and Larson sold XRP in the United States. So let me pause. On those points, it's very clear that the entire market moves together. So when did we see XRP move outside of what we otherwise would have expected? Well, when the SEC made the claim that XRP is an unregistered security of Ripple. But again, to be clear, you might say, well, see, that's proof. That means that XRP is associated with Ripple. But no. The price of XRP didn't plummet because of something Ripple did. The price of XRP plummeted because of something the SEC did. They made the claim that XRP is an unregistered security of Ripple. That's not proving that Ripple's actions move the price. In fact, it very clearly proves that the SEC moved the price of XRP. The lining, it's perfect. And in the coming days, XRP plummeted from whatever it was, I think it was 50-something cents down to 16 or 17 cents. Erasing something to the tune of like $15 billion worth of market cap. Just poof, obliterated, just gone. Ceased to exist for that moment. And then as far as the SEC proving that Garlinghouse and Larson sold XRP in the USA, well, look, my understanding, based on all publicly available knowledge, is that Garlinghouse and Larson intentionally sold only to individuals outside of the United States, specifically so that the SEC wouldn't have any jurisdiction over this case. So there's nothing shady about that. Hell, I'd do the same thing, wouldn't you? Do you want there to be even an opportunity that the SEC could jump in and claim anything? You know, do you want even the opportunity to be there for the SEC to come? So hell no. Now, if there's any exceptions to that, maybe that's the case. I haven't seen any evidence of it. Maybe that's the case. But either all or the vast majority of both of their XRP holdings sold outside the United States, SEC shouldn't have any power over that whatsoever. And so it just kind of makes you wonder how that's going to shake out in the end too. Anyway, John Deaton continues. In reality, the SEC's case may be so weak and desperate that it believes the only way to win is to prove that XRP itself is a security per se. The SEC, in essence, is asserting a but-for theory in the case. And so pause. Again, that just means effectively proximate cause for what ultimately has happened and the damages that have ensued. Alleged damages, right? Anyway, John Deaton then continues. For example, the SEC asserts Ripple created a secondary market for XRP. Therefore, all XRP, including XRP traded in the secondary market, are investment contracts with Ripple. In short, but for Ripple creating a secondary market, there would be no secondary market for XRP. And then he goes on to cite this, which I've highlighted this on the channel many times before. This is from the initial legal complaint that the SEC filed against Ripple, which states in part, the XRP traded, even in the secondary market, is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract. And so Paul's thinking about this. This is why he's talking about the but-for rule. That's what he's talking about here. Why wouldn't you, just to make sure that John Deaton and all these other XRP holders and all that, you could have prevented all that just by stating that XRP itself is not a security. But what John Deaton is getting at here is that their arguments are so weak, that may be the only argument they end up having. So no, that's what what he's postulating here is that's the reason they didn't make that point, is because it might be all they have in the end, because their position is so poor. John continues. Judge Torres herself recognized this broad, over-encompassing theory made by the SEC. If the SEC has difficulty proving Garlinghouse and Larson sold XRP within the jurisdiction of the United States, and the quality of evidence against Ripple and its executives are represented in these two emails, the SEC might just believe its best theory is the but-for theory. It's a stretch to say the least, but if the SEC were to be successful with its novel but-for test, although trying to disguise it within the Howey test, all of crypto is in danger. Think about that. Because you could apply it but for to anything else. Because again, it's just referencing the proximate cause of all this in the first place. And so then John Deaton wrote, i.e., but for Vitalik Buterin, Joseph Lubin, Ethereum is ... So you can see where he's going with this. It's them right at the heart of it. You could, if that were actually successful, and again, he's saying it would be a stretch, but if it is, and maybe this is what the SEC is going for, what cryptocurrency wouldn't be in danger? And then he wrapped up by stating, but for Satoshi Nakamoto, Bitcoin is ... Same thing. Apply it to whatever. Interesting thought. So I've long held the position, in particular as we started getting to the nitty gritty in the earliest weeks after all hell broke loose, after SEC filed this legal complaint against Ripple December 22nd of 2020. Like, as the facts came out, it just became more and more clear that the accusations, they don't follow any sort of logical thought process. And their claim, and there seem to be bullying tactics, and they use fraud-like language for a non-fraud case. They never claim that Ripple or any of the executives engaged in any sort of actual fraud, but they used fraud-like language in this case, and charged two executives at the top of Ripple, specifically, which is just unheard of. It's completely unprecedented. So what the hell are they doing? Well, they're bullies, and they're liars, and they don't believe the arguments they're making. They just seem to be wanting to expand their reach. These are power-hungry people. These are not good humans, and I don't believe that they believe the arguments that they're making. All right, now into this next piece, the Washington Post, and it's just a quick update, really, because I already covered this story. But here was the headline from a couple days ago: Feds arrest married couple, sees $3.6 billion in hacked Bitcoin funds. And wait till you see why I was laughing quite a bit when I discovered what I'm about to share with you. And so really all you need to know at this point is, in 2016, a certain quantity of Bitcoin, I think it was close to 120,000 Bitcoin, was stolen from a cryptocurrency exchange, Bitfinex, by a hacker. And then there was this couple living in New York, Ilya Lichtenstein, I don't know, and his wife, a rapper wife, by the way, more on that in a second, Heather Morgan, 34 and 31, age 34 and 31 respectively. So they were charged with conspiring to launder money. So it seems that the hacker stole all this Bitcoin from the exchange, then sent it to those two, this couple, don't know what the relation is with the hacker, and then those two were trying to launder the money. And they went through all sort of methods that they must have thought were particularly, impressive and hard to track. But they were able to track it apparently with great ease. And so they've been moving this Bitcoin around and trying to hide the tracks for a number of different transactions over the years, and they ended up getting caught. So that, in a nutshell, that's the story. Ended up being the biggest seizure in history, according to the Department of Justice. The biggest, period. Not just crypto, not the biggest crypto seizure, the biggest seizure at today, $3.6 billion. Well, why is this funny? Because these... I should have just showed you the damn headline. I think it was... oh no, here it is, yeah. Take a look at this. So, this tweet, here's a tweet from June 18th, 2020, from BitGo here. What the hell is BitGo? I meant to look this up. It's something to do with digital currency, delivering trust in digital currency with the industry's most complete offering of security, compliance, and custody. So there you go. So it's a crypto entity. And they put this tweet out linking to a Forbes article. And they wrote, "Protect your company and clients from cyber crimes." BitGo's chief compliance officer, Matt Perella, discusses strategies with Heather Ryan. More experts share tips to protect your business from cyber criminals. Again, Heather, she's one of the two. She's the wife of the other guy that got arrested as a result of the attempt to launder $3.6 billion worth of Bitcoin. This is her Twitter profile. This is her right here. There you go. That is the woman that with her husband had $3.6 billion worth of Bitcoin that wasn't theirs, and they're attempting to launder right there. And again, she was a contributor for Forbes. She wrote articles for Forbes, and here's one of them from June 18th, 2020 that she wrote, titled "Experts Share Tips to Protect Your Business from Cyber Criminals." Folks, you can't make this stuff up. You can't even make this stuff up. They got $3.6 billion worth of Bitcoin that was stolen, and then she, after this happened and is in possession of that quantity of Bitcoin, she's writing this article for Forbes explaining how to protect yourself from cyber criminals. She's a cyber criminal. This is absolutely astonishing. And look at her, she's also a rapper. I'll let this silently play in the background. This video, this is a, I guess, what do you call this? A music video that she made. So she's writing for Forbes, but she's also a rapper. I'll tell you what, talk about jack of all trades here. So talented, except for she's not. I listened to this whole thing. I won't make you suffer through the actual audio of this, but this is not art. Whatever this is, it is not art. It is very, very bad. It should not exist. It doesn't sound good. The lyrics are stupid. She has weird mannerisms. Like everything that she does in this is bad and is not music. Whatever she's doing specifically is not music. I don't know what the hell it is. It's something. It exists. I can clearly see it exists. It's on your screen right now, in fact. It is not music. This is weird. And she just sounds so awful, and it doesn't sound authentic the way she does it. And it's just crazy. Like this is the person. So then you're sitting here thinking, this is the person that was part of what ultimately became the biggest seizure of funds in history, according to the Justice Department.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.